Honourable Member for Wellington Halton Hills.
Madam Speaker, never has so much effort been put into renewing Parliament as has been put into renewing it over the past decade. Over $5 billion is being spent on renovating Parliament Hill. The centre block, with its iconic Peace Tower, has been shuttered since December of 2018 so that this magnificent building can be restored. Tons and tons of rock have been blasted out of the Canadian Shield. Some 40,000 truckloads of rock have been removed to create a pit 75 feet deep for a new underground structure. The leaded windows in the building have been taken out and are being restored. The copper roof has been replaced. The stonework is being repointed. The woodwork is being restored, and the mechanicals in the building are being completely overhauled. Confederation Building has had its windows completely removed and restored, and the outside of the building has been cleaned and repointed. The outside of East Block has been restored. Its stonework has been cleaned and repointed, and the copper roof redone. Here in West Block, the quadrangle has been turned into an atrium which houses this glass chamber that we now sit in. The stonework looks as bright as the day it was laid over a century and a half ago. And while Centre Block is still undergoing its renovations, the buildings on Parliament are sparkling with new renovations. But Parliament is more than its buildings. The essence of Parliament is its procedure and practices, its privileges, its powers and immunities, its authorities. The buildings are secondary. But while the buildings gleam and shine, particularly at night, the authorities of Parliament do not. The $5 billion in renovations on Parliament Hill belie a Parliament that is unable to do its job. The $5 billion in renovations on Parliament Hill belie a Parliament that is unable to fulfill its constitutional role as a legislative and deliberative body that holds the government to account. A Parliament that is unable to deliberate about the Sustainable Development Technology Canada Fund because it is unable to get the documents related to that fund. A Parliament that is unable to hold the government to account because it is unable to get the documents about the Sustainable Technology Development Fund. Madam Speaker, let us start from first principles. Our Constitution is the supreme law of this land. The preamble in Section 18 of the Constitution Act lays out the privileges, immunities, and powers of this House. The beginning of the preamble reads, "Whereas the provinces of Canada, Nova Scotia, and New Brunswick have expressed their desire to be federally united into one Dominion under the Crown of the United Kingdom of Great Britain and Ireland, with a constitution similar in principle to that of the United Kingdom." Section 18, which was reiterated by Parliament itself in Section 4 of the Parliament of Canada Act, reads, "The privileges, immunities, and powers to be held, enjoyed, and exercised by the Senate and by the House of Commons and by the members thereof respectively shall be such as are from time to time defined by Act of the Parliament of Canada, but so that any Act of the Parliament of Canada defining such privileges, immunities, and powers shall not confer any privileges, immunities, or powers exceeding those at the passing of such Act held, enjoyed, and exercised by the Commons House of Parliament of the United Kingdom of Great Britain and Northern and Ireland and by the members thereof." The preamble in Section 18 grants to the House of Commons the unfettered right to send for persons, papers, and records. The House of Commons has the unfettered right to order any and all documents. Its right to order the government or anyone to provide documents is absolute. Right. I quote from House of Commons Procedure and Practice, 3rd edition, 2017, edited by Mark Bosk and Andre Gagnon. "No statute or practice diminishes the fullness of that power rooted in House privileges unless there is an explicit legal provision to that effect, or unless the House adopts a specific resolution limiting the power. The House has never set a limit on its power to order the production of papers and records. Speaker Milliken also affirmed that absolute right of this House to order documents in his rulings of April 27, 2010 and March 9, 2011. Again, Madam Speaker, I quote from House of Commons Procedure and Practice, 3rd edition. By virtue of the preamble in Section 18 of the Constitution Act 1867, Parliament has the ability to institute its own inquiries, to require the attendance of witnesses, and to order the production of documents, rights which are fundamental to its proper functioning. These rights are as old as Parliament itself. The right to order the production of documents is as old as this place itself. The right to order the production of documents is fundamental to the proper functioning of Parliament. The right to order the production of documents is a constitutional power. It is an essential power for Parliament as a legislative and a deliberative body, so that we in this House can legislate, deliberate, and hold the government to account. There is no limit on the kinds of documents that can be requested. The only prerequisite is that the documents exist, that they are either in hard copy or in electronic form, and that they are located in Canada. These documents can be in the possession of government or of civil society or in the private sector. Again, Madam Speaker, I quote from Boscan Gagnon. And while this passage refers to committees, it equally applies to the House as a whole. The standing orders do not delimit the power to order the production of papers and records. The result is a broad, absolute power that on the surface appears to be without restriction. There is no limit on the types of papers likely to be requested. The only prerequisite is that the papers exist in hard copy or electronic format, and that they are located in Canada. They can be papers originating from or in the possession of governments, or papers the authors or owners of which are from the private sector or civil society, individuals, associations, organizations, etc. The power to order documents is absolute. Nothing can impinge on the right of this House to order documents. Not unwritten conventions, not common law, not even statute law. I quote from the 42nd report of the Standing Committee on Procedure and House Affairs of the 41st Parliament First Session. Since parliamentary privileges form part of the Constitution, laws must be interpreted and applied in a manner consistent with them. And where there is a conflict between privileges and statutory provisions, the statutory provisions are of no force and effect to the extent of the inconsistency. This constitutional principle is a fundamental postulate and organizing principle of Canadian constitutional structure and is clearly set out in Section 52(1) of the Constitution Act 1982 that provides the Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. The courts have recognized the special constitutional status attached to parliamentary privilege and the limitations it poses on their own jurisdiction and that of the executive. Madam Speaker, this government has failed to comply with an order of this House for the documents related to the Sustainable Development Technology Canada Fund. And this is not the first time. In the previous Parliament, the government also refused to comply with 4 orders of the House and its committee for the production of the Winnipeg lab documents. Even though the House ordered the documents be handed over in secret under lock and key so as to prevent the release of information injurious to national security. And incredibly, in the dying days of the last Parliament, the government had the audacity to take the Speaker of the House to court to try and use statute law to defy our constitutional law. It was only after 3 years that the government recanted and handed over the documents to the House. 3 years. Let's compare this government's treatment of Parliament when it asks for documents with how other governments treat their national legislatures. In the United Kingdom, in the fall of 2018, the House of Commons ordered the government of then Prime Minister Theresa May to hand over a solicitor-client privileged document in its unredacted form. This was a legal opinion prepared by United Kingdom Attorney General Geoffrey Cox, who prepared a legal opinion for the Cabinet about the validity of the Irish backstop in the Brexit deal. The Prime Minister resisted handing over the document to the House, and the House subsequently adopted a motion holding the government in contempt, indicating that it had to hand over this solicitor-client privileged document. The Prime Minister complied with that order and handed over the document forthwith. Let's compare it to what happened south of the border when an individual refused to hand over a document to Congress. Steve Bannon refused to appear in front of a congressional committee and refused to hand over documents to that congressional committee. He was indicted on one count of refusing to appear in front of a committee and a second count of refusing to hand over documents to a committee, and he served 4 months in prison for that refusal. That's how important the constitutional order in other democracies treats the right of a national legislature to get documents from the government or from individuals, from civil society. And that's why the founders of Confederation wrote the preamble to the Constitution Act 1867 and wrote Section 18 of that Constitution Act. Let's compare this government's treatment of Parliament with previous governments. In 1990 and 1991, during the government of Prime Minister Brian Mulroney, the Solicitor General refused to provide the Standing Committee on Justice and the Solicitor General with documents, citing privacy issues. The Standing Committee on Privileges and Elections concluded that the Standing Committee on Justice and the Solicitor General had the right to insist on the production of these documents and recommended that the House order the Solicitor General to comply with the production order. The House subsequently issued a production order to be presented, that the documents be presented at an in-camera meeting of the Standing Committee on Justice and the Solicitor General. The government complied with the order at the next meeting of the Standing Committee on Justice and the Solicitor General, and members of the committee examined the unredacted version of the documents. In 2009, during the government of Prime Minister Stephen Harper, the Honourable Ujjal Dosanjh moved the following motion, which was adopted by the House. That, given the undisputed privileges of Parliament under Canada's Constitution, including the absolute power to require the government to produce uncensored documents when requested, and given the reality that the government has violated the rights of Parliament by invoking the Canada Evidence Act to censor documents before producing them, the House urgently requires access to the following documents in their original and uncensored form. All documents referred to in the affidavit of Richard Colvin, dated October 5, 2009. All documents within the Department of Foreign Affairs, written in response to the documents referred to in the affidavit of Richard Colvin, dated October 5, 2009. All memoranda for information or memoranda for decision sent to the Minister of Foreign Affairs concerning detainees from December 18, 2005 to the present. All documents produced pursuant to all orders of the Federal Court in Amnesty International Canada and British Columbia Civil Liberties Association v. Chief of the Defence Staff for the Canadian Forces, Minister of National Defence and Attorney General of Canada. All documents produced to the Military Police Complaints Commission in the Afghanistan public interest hearings. All annual human rights reports by the Department of Foreign Affairs in Afghanistan. And accordingly, the House hereby orders these documents be produced in their original and uncensored form forthwith. Madam Speaker, I want to emphasize what the order said. The House hereby orders that these documents be produced in their original and uncensored form forthwith. In other words, the documents about the Afghan detainees were to be released to the House and to the public immediately, without redactions, for the entire world to see, including the armed combatants fighting Canadian forces in Afghanistan. The order required the government to immediately and publicly, without any redactions and without any considerations to the injury that could result to the ongoing Canadian Armed Forces military operations in Afghanistan, to be released. Understandably, the Harper government was reluctant to publicly release the information. Speaker Milliken ruled that the House had an unfettered right to these documents, but also sympathized with the government's concerns about publicly releasing information that could be injurious to ongoing Canadian military operations, and encouraged the parties to work together to resolve it. The government did exactly that, and 6 months later, an ad hoc committee was struck, and the government handed over all the documents to that ad hoc committee in the summer of 2010, all the documents without redactions, and the committee began its work. There are two things to note about the Afghan detainee document order that was different and distinct from the Winnipeg lab document order. First, there were no measures in the Afghan detainee order to prevent the release of information injurious to national security or injurious to the conduct of Canadian military operations. The order mandated that all the documents be released forthwith, publicly, without redactions. Second, the government understood its obligations to Parliament and worked with the opposition parties to produce the documents to the ad hoc committee in 6 months. And in comparison, the Sustainable Development Technology Fund Canada documents contain no information injurious to national security. The government's explanation for defying an order of this House for those documents is that it could be a violation of charter rights. This argument is weak and thin, and one suspects that it is weak and thin because it was the only argument that the government could come up with in response to the order. One suspects is that if the reference to the RCMP wasn't in the order for the documents, the government would have found another flimsy excuse not to hand over the documents. One suspects the real reason why the government will not hand over the documents is not because it would be injurious to the rule of law, not because it would be injurious to charter rights, but because it would be injurious to the government's political fortunes.
Right.
There are several ways to end this debate, but there are only two ways to end this debate in the right way. One is for the government to hand over the documents.
Right.
And the other is for this Parliament to be dissolved and to take the matter to the Canadian people for their decision at the ballot box.
Yeah. There you go, Michael. Questions and comments. The Honourable Member for Pierrefonds-Dollard.
Thank you, Madame la Présidente, and I have immense respect for the member opposite. The member opposite has the capacity to disagree without being disagreeable, unlike many of his Conservative colleagues who continuously go into the bottom of the gutter into ad hominems. So I have immense respect for the other member opposite, but I'm really here to ask the question I just asked his colleague who could not answer and evaded the question. I want no evasion in this answer that the member opposite will be providing, which is, why will his leader not become security cleared? The member opposite has stood in this Parliament on the issue of foreign interference. Each and every the opposite party not willing to do so, especially if he is looking to protect the privileges of this House. I don't get it.
Honourable Member for Wellington, Halton Hills.
Madam Speaker, quite simply, because the Treasury Board Secretariat's policy on government security would require the leader to sign a certificate or an undertaking not to reveal any information to anyone else under threat of criminal prosecution. That's right. A security clearance process the Prime Minister himself has not gone through. And that is why the Leader of the Official Opposition has said that the Prime Minister needs to release the information of parliamentarians compromised by foreign interference so that this House can make a decision about those members and whether or not they can continue to sit in this House, and so that Canadians can go to the ballot box in the next election informed about the choices that they are going to make, particularly when it comes to members of this House who colluded with foreign powers to the detriment of the interest of this country and in violation of their oath.
Take that to the bank. Questions et commentaires, l'honorable député de... Order. Honorable député.
The Honourable Member for Pierre-Bouchelet, Patriote Verchères. Thank you, Madam Speaker. I wanted to rise to speak to my colleague's speech because in his speech, he talked about the British North America Act. He used this to strengthen his argument. He mentioned extracts of the legislation. He mentioned them as fact. One point in particular that I wanted to raise. He said that the British North America Act was based on a joint agreement between the 4 provinces existing at the time, Lower and Upper Canada, Nova Scotia, and New Brunswick. But the truth, Madam Speaker, and I don't know if my colleague is aware of this, is that actually it was the fruit of an alliance between the Cartier Conservatives, the Liberals from Upper Canada, and the Conservatives in Upper Canada. Whereas the Reds in Lower Canada, Quebec, were very against this, and so did Nova Scotia. In fact, there was even a unanimous vote against the British North America Act. But no one listened to that. New Brunswick, as well, wanted to negotiate a different treaty than the one that was imposed. So the reality of this legislation is that it is colonialist legislation that the population never asked for. What would my colleagues say?
Halton Hills.
Merci pour la question.
I'd like to thank my colleague for the question. The Constitution of Canada is the only constitution we have here in Canada. Yes, it's not perfect, but it's the only one we've got. And that's the reality. So we're going to respect the Canadian Constitution. And in my opinion, there are many issues that perhaps in the future we can improve in the Constitution, but for the moment, we need to follow the Canadian Constitution. Because the rule of law is a basic aspect of the existence of everyone in Canada. It applies to both citizens who support the Constitution and citizens who have issues with the Constitution. Everyone needs to comply with the Constitution and the law here and everywhere in Canada. The Honourable Member for Rosemont-la-Patrie. Thank you, Madam Speaker. With your leave, I will come back to 2024 and leave behind 1867. We've had allegations of political interference, serious allegations. We've heard some about the Liberal Party, but also about the Conservative Party. The leader of the Conservative Party, however, is refusing to get his security clearance. He's refusing to hear all the information that would enable him to know that perhaps something is going on in his caucus or with former candidates. The leader of the Bloc Québécois, the leader of the NDP, the leader of the Green Party, all received that security clearance. Why do the Conservatives prefer ignorance over knowledge? The Honourable Member for Wellington-Halton Hills. That's very simple, Madam Speaker. We don't believe that this information should remain secret. We need to make this information public. To give Canadians the information they need in the next election to make an informed choice based on the information in the report.
This information should be secret. We believe that it should be made public. We believe that Canadians should know which of their candidates in the next election were compromised by foreign interference activities. And so that's quite simply the reason why we're calling on the information to be released.
Member for South Shore St. Margaret's.
Thank you, Madam Speaker. I'd like to actually take the questions back to the debate that we're having today on the failure, the cover-up of the Liberals to provide the documents as ordered by this House. And the member gave perhaps one of the best speeches in this long, sordid tale of the constitutional requirements for the government, the Crown, to not defy the will of the people. And what I found interesting is that what we have here is the Privy Council Office. The Prime Minister's Department is the one that ordered the redactions of departments. And I'd like the member, if he could, to explain why he thinks the Prime Minister's personal department thought that it could redact under Access to Information and Privacy Act the order of the House, which was not part of the order of the House.
The honourable member for Wellington, Halton Hills.
Thank my honourable colleague for the question. And, I go back to the 1991 case during the government of then Prime Minister Brian Mulroney, where the government of the day said that they were not going to hand over the documents related to the Solicitor General because of privacy concerns. The House ordered the documents be handed over, and the government complied at the following meeting of the Standing Committee on Justice and the Solicitor General. So clearly Parliament has the right to these documents, and no statute law, no common law, nothing can interfere with Parliament's absolute right to call for the production of documents. And again, I quote from Section 15 of the Constitution Act, which makes that very, very clear. It says that, if I can find the quote here, Madam Speaker, it says that I'm looking for the quote here. It says that the Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect, and that would include the Privacy Act.
The honourable member for Nepean.
Thank you, Madam Speaker. Madam Speaker, the honourable member quoted quite a bit from the preamble of Constitution and other laws. He had a lot of authorities quoting on the subject he was speaking. I do agree with him that the House of Commons has got the power to legislate, deliberate, and hold the government to account, which we do. In one of the things authorities he mentioned, said, on the surface it appears to be without restriction. I think this was in reference to the power to summon documents, ask for documents. Again, I said, quote, on the surface it appears to be without restriction. The key word in that phrase is the word appears. It is not absolute. That's number one. Number two, I think he also mentioned the parliamentarian or the minister in the UK Parliament sent to prison. I don't think it was for his refusal to produce the documents. I think it may be for his refusal to appear before the committee. Maybe the member can clarify.
Honourable member for Wellington, Halton Hills.
Well, thank the honourable member for the question. In answer to the first question, the word appears is used because the only restrictions on Parliament's absolute right to order the production of documents is that those documents be present in Canada and not extraterritorially, and that they exist. That is why they use the word appears in the previous sentence. With respect to the question about the UK case, it was a legal opinion issued by Attorney General Geoffrey Cox to the government, the cabinet of then Prime Minister Theresa May. This was a solicitor-client privilege document. The document was released in full, unredacted, publicly to the House of Commons after the Prime Minister was held in contempt and ordered to hand over the document.